So labor law as a concept it's incredibly broad. It's something that most of you may have touched, may not have touched, but it will come up at some stage during your lives. So I'm going to start right at the very beginning. What labor law is. A few years ago, trained paralegals as a side hustle while I was doing my articles. And an interesting question that I asked my class first up was, what is labor law? Can anyone have a stab in the dark as to what it is? And one very eager student piped up and said, maternity rights, and that's it. And it goes much, much further than that. So I'm going to try and limit it to what is relevant to you, but South African labor law, as far as where it can be found and the sources of it, are quite limited. So we have three main pieces of legislation. And what we mean by legislation is a written document setting out certain laws that has been promulgated by Parliament. So it applies throughout the country. It's a written document, you can refer to it, you can apply it. So the three main pieces of legislation in South African labor law are the Labour Relations Act, the Basic Conditions of Employment Act, and the Employment Equity Act. So many of you, when you've been walking around in the hallowed halls of various businesses, would have seen this random poster on the wall, the Basic Conditions of Employment Act. It is not there because it's pretty, it is there because by law an employer is required to stick it up on the wall. And what the Basic Conditions of Employment Act does, for example, is it sets minimum standards what you as an employee are entitled to. What you can claim as annual leave, what you can claim as certain formalities and contents of your employment agreement, how much family responsibility you can take, what happens if you adopt a child, how much leave can you take in that scenario? Does it make a difference if that child is adopted or not? So the Basic Conditions of Employment Act is incredibly important. Some of you will be employees one day, some of you may already be employees, some of you may be employers. It is incredibly important that you know what these documents say, and luckily the written part of labor law, the acts as far as the nitty-gritty is concerned, are quite limited. And it's quite simple. So labor law is, as much as I would love to have used Megan's term that it is an art, it is not. It is pragmatic, it is equities-based, it is reasonable. That is the ultimate aim of labor law. Everything that labor law does and creates is geared towards an expeditious and fairness-based result. So much so that labor law essentially operates outside of our traditional hierarchy of the court. So you guys may have heard these random concepts such as a small claims court and a magistrates court and a high court and the Supreme Court of Appeals, all those wonderful things. The labor law operates completely outside of that. It's got its own set of hierarchy of courts. So the CCMA is something all of you would have heard about. I deal with very aggrieved, very angry employees on a daily basis, and the first thing they do, whether they have a basis for it or not, is to say, I'm going to take you to the CCMA. I don't know what it means, I don't know what that acronym actually spells out at the end of the day, but I'm going to go there and I'm going to bring you with me. And as much as most employers also don't understand the law, and they hear CCMA and go, what do we do? What do we do? Let's phone a labor lawyer. If you just look at the legislation, it would all make sense. So getting back to the initial point I was making, labor law is confined to three main pieces of legislation, and then you have what is called common law. So common law is essentially laws that are not recorded or codified in a national piece of legislation. It is found in case law. So you'll have a matter before the labor court, an interesting issue of labor law. The court will decide it, the court will make a decision, and that decision will then be followed in subsequent disputes of a similar nature. And that's called precedent. So that is essentially in a nutshell where our labor laws come from. And it's so much broader than just those three thinking about it, because you have occupational and health issues, you have employment equity, which is becoming a big hot topic at the moment. I don't know if any of you have been doing any reading or following the news, but there has been a recent amendment to the Employment Equity Act, which has shaken up the whole field. So specific business sectors are now required to have certain employment equity targets. A certain percentage of a particular workforce has to be diverse, which has thrown the entire way in which a company's business is structured and their workforce is structured into a new light. And obviously there are severe penalties if you don't apply or comply with the provisions of the law, and it's a bit of a snowball effect. So it's important for employers, especially those of you who are going to be employers one day, to ensure that you know the law. Most of the time when you go to a labor lawyer, it may already be too late. You may have already infringed that employment right. You may have already unfairly withheld that benefit. And then it's about damage control. And then what you end up doing is you end up settling. And, you know, settling is one of those things that becomes an inevitability in dispute resolution, but it leaves a bad taste in the mouth for a lot of employers, especially in a scenario where you're dealing with a dismissal where the employer believed what they did and how they acted was completely fair, but they still, in a sense, lost. And again, we have this saying that a good settlement is a scenario where both parties walk away from the table extremely unhappy. So those three acts that I mentioned deal with most of the essential central elements of labor law. What your rights are. What happens if you proceed on an unprotected strike? What do you do if you believe you've been unfairly dismissed? Where do you go? What is your time limit for acting? As far as benefits and pensions and medical aids are concerned, what are you entitled to as a basic minimum right? And that's what South African labor law tries to do. It doesn't say to an employer, this is where you have to go. This is what you have to offer your employees to be a great employer, to be an employer of choice, however you want to phrase it. What it says is this is the minimum standard you have to meet. If you want to exceed that, fantastic. Your employees will love you and you will attract a greater workforce. But this is the minimum standard you have to meet. Okay. So just to give you a basic idea of so the other thing that our labor laws do, very important, create our labor fora, which is the various courts that you take your disputes through. So right at the bottom is the CCMA, which is the Commission for Conciliation, Mediation and Arbitration. And then your next step up is the Labor Court, which has the exact same jurisdiction or authority as a high court, but it functions as a specified labor court. Doesn't do any other work. And then from there you go up to the Labor Appeal Court, which has a similar type of jurisdiction to the Supreme Court of Appeals. And then if you are still aggrieved as an employee or an employer, you go to the Constitutional Court, which is where legal dreams either succeed or go to die. That is our final and highest determinative court. If you get kicked out of the Constitutional Court, you are done. You can't go to The Hague. You're done. That's it. That's the end of it. Okay. So the other important thing that I want to touch on, and I think this is going to be quite important for you guys as you progress in your careers, is this issue of what is an employee and what is an independent contractor. So I'm not sure if you guys have any idea what the difference is between those two categorizations, but it's incredibly important that you know what the difference is, because there are different rights, different responsibilities, different consequences that apply to each scenario, and getting it wrong can be fatal, it can be expensive, and you will end up very, very unhappy. So the definition of an employee is very easy. It's defined in the Labor Relations Act. For those of you who are legal nerds, Section 213 of the Labor Relations Act. And it's very simple. The labor law is supposed to be simplistic, and it's supposed to be open to the layman. So the function of labor law is for any employee to go and read the law and understand what their rights are. Not to have to go to a labor lawyer where they pay them 3,000 Rand an hour, that's not my rate, by the way, I charge less, 3,000 Rand an hour to advise them on something that they could very well interpret themselves if they had. The thing is, the law is intimidating. It's intimidating to most people, and labor law specifically shouldn't be. It's simple. It's focused on reaching a resolution as quickly and as simply as possible. So an employee is defined in the Labor Relations Act as any person, very importantly, other than an independent contractor, who renders work for someone or the state, and who receives remuneration or is entitled to receive remuneration for that. Very simple, very straightforward. The second part of that definition does muddy the water somewhat. And the second part of the definition says that anyone is also an employee who assists an employer to carry on or further their business. That makes it a bit more ambiguous. But ultimately, if you are an employee, under South African law, if you can categorize yourself in accordance with the definition in the Labor Relations Act as an employee, the full spectrum of South African employment laws and protections apply to you. And that is important. South Africa is one of the most employee-centric labor law systems in the world, meaning that as an employer, you are almost immediately on the back foot. I know this because I act majoritively for employers. difficult. You think about what it's like in America, or what the movies and series portray it to be like in America. You walk in the morning, the guy goes, "I don't like your face today, you're fired." There's the door. And to a certain extent in American law, they can do that. All they have to show is cause. In South Africa, it's a completely different kettle of fish. It is incredibly burdensome, it's incredibly difficult, and you need to ensure as an employer that you have a silver bullet case. So getting back to what I was talking about, I got a little bit distracted there. But essentially, so that is the definition of an employer, an employee. And the importance of that is because you then qualify for all the various protections, which means that you cannot simply be dismissed, you cannot simply be terminated. There's a very specific process that an employer has to follow to dismiss you, and to dismiss you fairly. I'm talking so much that the microphone ends up over here. An independent contract, on the other hand, is a bit of a nebulous concept. It's not something that is defined specifically in any bit of legislation. It's not defined specifically in any case. Essentially what it is, it's someone who renders a particular service to achieve a particular result in return for remuneration, but essentially who is their own boss. Someone who determines their own hours, who doesn't work under the control of the principal. So just to give you an idea, obviously in an employment relationship, you have the employer and the employee. That's simple. In an independent contractor relationship, you have the principal, or the client, to use a more colloquial term, and the independent contractor. So an independent contract comes in various forms. Sometimes they're called service agreements, sometimes they're called service level agreements, sometimes they're called consultancy agreements, but the basis of it is exactly the same. You have been engaged contractually to render a particular service or to achieve a particular result, most of the time within a particular time frame, in return for a fee. And in that scenario, and what is really important with the differentiation is, an independent contractor is not entitled to employment rights. They are not an employee. They cannot take that person to the CCMA. They cannot demand certain minimum benefits. They cannot demand annual leave. So the example that I always use when I explain it to clients to break it down essentially is that if you think of a painter, you get a painting company to paint your house, or a plumber even. You get a plumber in to fix your pipes. You can't tell that plumber, I want you to use those tools, and I want you to work between these hours, and this is what I will pay you, and you will be restrained, I will have you sign a non-compete, and I will deduct tax from your fees. You cannot do that. That plumber is going to be out of your house onto the next job as soon as possible. And that is essentially where the defining line is. Does the person have, or the contractor, let's call them the contractor, have a certain amount of independent control over what they do, how they do it, and the tools they employ to achieve a particular result? How dependent are they on the income that they received from the principal? Obviously, if you look at a scenario objectively and you see that the service provider is receiving monthly income from only one client, they have an agreement that says you will work for us exclusively. That kind of flies in the face of what the law considers to be a traditional independent contractor agreement. And differentiating between the two is difficult because a lot of the time people enter into these agreements, and contracts are one of those things that people are so keen to conclude at the beginning of it because they want this thing to start, they want this wonderful relationship to carry on, and then when things go wrong, that's when you start realizing where the holes in the agreement are. We should have agreed this and we didn't agree that, and it only happens when there's a dispute, 9 times out of 10. So what our courts have done is to aid this distinction between the two. This happened about 10, 11, 12 years ago. They made an amendment to the Labour Relations Act, and they created a deemed section. Essentially, what Parliament did is they said, if these particular elements are present in this relationship, it will be deemed to be an employment relationship, unless one of the parties can prove that it's not. And essentially, what that provision says is, regardless of what the contract is called, and the reason why this was implemented is because what a lot of naughty employers did over the years to think, I want to get away from having to go through a week-long disciplinary process and having to issue warnings and that. I want to, as within any independent contractor agreement, have a clause in my agreement where I say I can terminate you on a month's notice for no reason whatsoever, provided that I give you a month's written notice, as is the case with most independent contractors. How do I get around that? What I can do is I can get all of my employees on independent contractor agreements for a year and just renew them until they retire. And Parliament's response to that was Section 200A of the Labour Relations Act, and it's this deemed provision clause of the Act. And essentially what it says is there are certain elements. If one of these elements are present in a relationship, regardless of what you call that relationship, it will be deemed to be an employment relationship, unless you can prove the contrary. So that's incredibly important, because not everyone is skilled at concluding agreements. Not everyone is skilled at ensuring that the particular clauses differentiating the two categorizations are in an agreement. Very few people, lay people, are skilled at that. And very few people think initially when they conclude the agreement that they need attorneys to look it through. You have, we've agreed. I'll do this and you'll do that, and let's hoy it in a one-page agreement and we'll sign it and it'll be fine. And then things go nuclear after 2 years. And completely lost my train of thought. So the important thing is that what a lot of people do is they call an agreement an independent contractor agreement. And both parties may actually in reality believe that that's what it is. But then a dispute arises, the contractor is terminated, he or she does not like the fact that they're terminated, they disagree with the grounds on which they've been terminated, and they write to the principal and say, actually, I think I'm an employee. And my termination on a month's written notice is unfair, and technically what you're required to do is to follow a formal disciplinary process, which I wasn't afforded. What happens then? Then you sit with a scenario where you have a contract that isn't quite clear on what the relationship is, and parties on two opposite sides of the spectrum as to what their rights and obligations are. Now, what Section 200A of the Labour Relations Act says is regardless of what is in that contract, and regardless of what it is called, and one of the first clauses you'll find in an independent contractor agreement is the parties expressly agree that this is not an employment relationship. Expressly. Use it 4 times and repeat it in the following 3 subclauses. But if a court looks at that, and the court believes that the nature and the effect of the relationship is actually more akin to an employment relationship, then the court will say, sorry, this is an employment relationship. And you, the employee, have available to you the entire plethora of employment rights that we afford our employees. What are the consequences of getting it wrong? Well, the consequences of getting it wrong for the employer are much more severe. Because if you think about it, let's say you've had someone on an independent contract quite innocently for 5 years. You haven't deducted a single rand in income tax. You haven't paid UIF. You have not restrained that employee, meaning that you have been feeding them trade secrets for years without preventing them from competing with you the moment that that agreement is terminated for whatsoever reason. You are left in serious trouble. The employee, on the other hand, or the contractor, skips down the road, paved with wonderful, oak trees and flowers, thinking, well, I can go to the CCMA. And not only did I manage to get myself out of this contract, but I can now claim compensation, I can claim unfair dismissal, and just, it's a beautiful, rosy future for me. That's why it's so incredibly important to ensure that when you, as a principal and as an independent contractor, decide on how you're going to frame that relationship, that you ensure that the proper contractual mechanisms are in place to ensure that it's quite easy for a court to say ultimately one day, this is what it is, and this is what it isn't. Now, how do we achieve that? It's reasonably easy to differentiate the two because an employment agreement has to have very specific clauses in there. Annual leave, benefits, UIF, restraints of trade in most cases. Those things are not necessarily in an independent contractor agreement. But the main kind of mechanism that the court will imply is something we call the dominant impression test. If I look at that relationship objectively, what is the dominant impression that I get from the relationship between the parties? And in coming to that conclusion, a court will really look at 3 factors. The degree of control, in other words, the principle in that relationship. How much control did that company or that person have over the manner and the timing and the tools applied, for example, by the independent contractor in performing what the parties mutually agreed would be the ultimate end? Then, very importantly, and this is normally the... sorry, I'm being flagged down at the back there. And this is normally the indicator as to whether you have this type of relationship or not, is whether you are economically dependent on the other party. So my first clause that I prepare when I draft an independent contractor agreement is you are free to take whatsoever work you want from whatsoever quarter it comes from, provided that it doesn't interfere with the scope of services that you are required to deliver to me. Most of the time, that suffices. But I guess the lesson to be learned from this is whether you're an employee or an employer or a principal or an independent contractor, it is incredibly important that you determine the rights up front in that contract. And as Meg said, the contract is the be-all and end-all. It is what establishes that relationship, and it is what will eventually determine whether that relationship is mutually fruitful for both parties or not. Am I completely out of time? Can I not deal with dismissal? Okay, sorry. I thought I was going to have one of those shepherd's crooks that come out from the... All right, so that's an independent employee relationship. The barrier between the two, incredibly important. The other thing I want to talk about is, and this is again, as I alluded to earlier, people love talking about the CCMA, people love threatening the CCMA, but they don't know what it is. They don't know how it works. They don't know what their rights are. They don't know what their time periods are. You have employees saying, I'm going to go to the CCMA, and a year later they bring their claim, and you can't. You know, it'll fall flat on its face. So what is a dismissal? That's what I'm going to get to next. What is a dismissal? In South African law, we call it a dismissal. We don't really call it firing. You know, it's a bit of a vulgar term. Dismissal, it's got a nice ring to it. But essentially what it is when there's a unilateral termination of the employment relationship by the employer. And a dismissal is important because for you to be able to go to the CCMA, and the favorite mechanism for going to the CCMA is on the basis of an unfair dismissal. The first thing you have to prove as the employee is that you were actually dismissed. And believe it or not, some people cannot do that. They bring an unfair dismissal dispute, and the first preliminary point that the employer raises is, you were not dismissed. You were never an employee, you were an independent contractor. I couldn't dismiss you. But that is your first hurdle. I was dismissed. Okay, so a dismissal is essentially when an employer unilaterally, without agreement, terminates an employment relationship. So if you resign, that's not a dismissal. That is you as the employee unilaterally terminating the employment relationship of your own accord. I get a lot of questions from clients about mutual separation agreements. I don't know if any of you know what that is. So what a lot of employers will do is they'll say, okay, I have an employee that is not performing well. Do I put them through 3 months of burdensome, resource-sucking, poor work performance process management, or do I offer them a mutual separation? And that essentially is where the employer goes to the employee and they say, listen, I'm gonna have to put you through a poor work performance process. You're not gonna like it, we're not gonna like it. It's probably gonna end up in your dismissal. Should we just call it quits? You know, I'll pay you your month's salary, I'll pay you 2 months on top of that, and there's the door, goodbye. A lot of employees don't know their rights and they think, well, I didn't resign, which means I can go to the CCMA. And you can't. It's a mutual separation. It doesn't really fall within the definition of a resignation or dismissal. It's somewhere in between, but the fact of the matter is that it's not a dismissal. And in order for you to have standing before the CCMA, you need to be able to prove that you have a dismissal, which you won't have in that scenario. Okay, so forms of dismissal. In South African law, there are 3 recognized grounds of dismissal, which are misconduct, which is what we all generally know. You punch a client in the face, you will be dismissed. Okay. You share confidential information with a competitor of your employer, you will be dismissed for misconduct. Your employer walks into an office where you have put a please don't disturb sign on the sliding door only to find you watching Netflix. You will be dismissed for misconduct. Okay, so that is the most common form, misconduct. Theft, all of those things, huge umbrella term, but you've done something wrong and the fault lies with you and your employer dismisses you for that. Then you have what is called incapacity. So incapacity is a no-fault dismissal, meaning that it's not the fault of the employee, they didn't intend to do anything wrong, and that's basically divided into 2 broad categories. So you have poor work performance, which essentially comes down to an employee who simply cannot, despite their best efforts, discharge the level or the quality of services that their employment relationship requires from them. And then you have incapacity due to ill health or injury. You are, for example, contracted by South African Rugby to, you are a South African rugby player, you're under contract, you have to obviously be physically capable. You are in a car accident and you are no longer able to maintain or to honor that employment contract due to a physical issue. What does your employer do then? So if your employer then ultimately decides to dismiss you, and they can only do that after going through a very rigorous process, it will be a dismissal for incapacity. Then you have retrenchment, and we all know what retrenchments are. It's where a company is financially distressed, or where they decide to modernize or add an additional technological arm to a company, and certain positions become redundant. Then they go through a retrenchment process, and that ends up in a dismissal, also a form of no-fault dismissal. And there are very different processes for each, which I'm not going to bore you with now. But essentially what it comes down to, in order for you to be able to show that your dismissal was fair. So if you are an employer, for example, and you are dragged before the CCMA for an unfair dismissal claim, you have to show two things. You have to show that that dismissal was substantively fair and that it was procedurally fair. And this is where South African labour law becomes incredibly burdensome. So you as the employer have to show that the reason for the dismissal, the substantive element of the dismissal, was fair. You had a good reason, that employee knew what they were doing was wrong, or they could reasonably have established that what they were doing was wrong, and they did it anyway. And that the procedure you followed was fair. Now, the problem with that kind of setup, and I always explain it to my clients by referring to these American movies where it opens and you have this old disgruntled detective who was fired from the force because he's an alcoholic, and he sits there in his lazy chair in his apartment just stewing about this murderer that got away. And he got away because some idiot who arrested him didn't read him his Miranda rights, which is a procedural issue. In South African labour law, it works kind of similar. You as an employee, you could have done something egregious and be dismissed. But you take it to the CCMA, and if your employer did not follow a proper procedure, you could still walk away with a decent chunk of money in your pocket, because the CCMA will still order compensation in that scenario. So just to give you a quick overview of how it works in the CCMA with regards to an unfair dismissal, from the date of your dismissal. So let's just say you're dismissed for misconduct, you have to have gone through a disciplinary hearing, the independent chairperson or the chairperson of that hearing issued a ruling dismissing you. You have 30 days from the date of that dismissal to refer a claim to the CCMA. If you do it late, it is incredibly painful, because then you have to go through a process called condonation, where you have to explain to the CCMA in painful detail why you're late and why they should still allow your matter to be brought before the CCMA. That is incredibly important, because if you don't get condonation, your case is dead. That is it. You can't bring it again. So you've got 30 days to refer it. It's then referred to a very annoying process called con-arb. And con-arb is labour speak for conciliation/arbitration. So the first process is conciliation. No attorneys are present, probably for the best. We tend to complicate things unnecessarily. So you have a commissioner who sits with representatives of the two parties. There's the employee on the one side and the employer's representative on the other, and they try to facilitate a settlement. Commissioners push settlement very, very hard in the CCMA, because they don't want to have to deal with an arbitration. Okay, so they want to get the parties into a situation where they settle. If the matter does not settle at conciliation, then it moves to arbitration, and arbitration is essentially a little trial. Each party gets to state its case, they get to lead documentary evidence, they get to lead witnesses, at the end of which the commissioner will make a decision. Then you go to the labour court and the labour appeal court until you have no more money or no more remedies, and it goes away. Okay. So before I get forcibly pulled off, that's me, I'm going to hand over to Arinda, who will be dealing IP and copyright.